So you'll see that message on your screen that we're live streaming.
I don't
And
think I've ever seen Mr. Callisto with glasses on. Doesn't look like him.
can we confirm it's you, Eric? You're muted.
The slow decay is starting.
Don't even start. I was going to mention I get the service lists are incorrect sometimes because I'm wearing the wrong glasses when I'm typing them, and then
Oh,
I apologize. Like some of the email letters get moved around a little bit. But I think our live stream's going, so let's get started. Let's get on the record. We're in docket 4890 CW 102. It's the application of the Village of Pulaski for various water construction items. Won't go through the whole docket title. We're here for the pre-hearing conference. My name is Michael Newmark, Administrative Law Judge for the PSC. And we are here on Zoom for our pre-hearing conference, doing the usual identifying parties, schedule issues, and facilitating matters. You all know that we've been involved in a similar case, related cases with the Village of Howard. But now we're here to set the process for the Village of Pulaski's case. Let's start off with our appearances. So we do have our service list. Like I mentioned, hopefully all correct. I think no emails have bounced since the last time I used this list. But let's start off with appearances from the PSC.
Attorney Evan Whites appears on behalf of the Public Service Commission. Good afternoon.
All right, now Town of Pittsfield.
Apologies. This is Vanessa Wishart from Stafford Rosenbaum on behalf of the town of Pittsfield, and Rick Manthe is joining me as well. Just one note, Your Honor, I think that our firm name is listed incorrectly on the service list. Just missing an N.
Okay. All right. Wow, that's a big one. Okay.
Thank you.
All right. How about Village of Howard?
Eric Callisto, Michael Best for the Village of Howard.
Okay. And Village of Pulaski.
Brian Cahill and I believe Mark Bender is also on.
Yep, see you there. All right, great, thanks. All right. So we do have our parties identified. Looks like we're all in attendance. So we have the Village of Pulaski, Town of Pittsfield, Village of Howard, and similar to our other dockets, we have that party identifier. If you could use those initials for when you're filing documents in the case, that would be useful. So we all know we're on the same page. The issues are the standard certificate of authority issues that we use in water construction cases. Any comments on that?
The issues are appropriately described.
All right. And the schedule. So this schedule mimics the schedule in the Howard dockets. Like I had mentioned during the Howard pre-hearing conferences, it was my intention to issue or order identical schedules in these cases due to their related nature. Any comments on the schedule?
Thank you, Your Honor. I've had a chance to talk with folks at Village of Pulaski and their consultants, and from our view, I think trying to force this proceeding into the same schedule is untenable for a couple of reasons. First, I'm still trying to figure out a financial expert, honestly. The expert who had done the rate analysis is uncertain whether they'll be available to testify in this matter. I hope to know whether that is in fact true in the next week or so, but that could put a huge fly in the ointment. And then the other thing is we just got data requests from the commission staff, and those data requests really read like an incompleteness determination. So there's a fair bit of work that
I'm sorry, you broke up. Those data requests read
Sure.
like?
Almost an incompleteness determination. And so there is a significant amount of work that our technical experts will need to do in the next 2 weeks. And so to have them responding to those is really part of completing the application and completing the testimony by the 23rd is going to be a tall task.
Okay, that's it. So any comments from the parties?
This is Eric Callisto, Your Honor, on behalf of the Village of Howard. I understand where the Village of Pulaski is, and I've reviewed the data requests from commission staff and don't disagree that they are substantive. We talked about this issue when we had the pre-hearing conferences for the two Howard dockets, and I think we had some back and forth among the parties, and I think the word that was used was binary. Is this a binary choice for the commission? Meaning, do you approve the Howard project or do you approve the Pulaski one? Well, I think most of us, if not all of us, agreed that it's probably not fully binary. That there's no doubt that these two cases are very directly related to each other, at least from the wholesale provision of water to Pulaski, which is a relevant piece of information for the Howard dockets. I'm sympathetic to Pulaski's position, kind of given the state of their application, and
Oh,
I would say.
I'm sorry, you muted sort of in the middle there. So you just ended up with the status of the application.
Yeah, and so I am sympathetic to it. What I would suggest is if Pulaski's not in a position to get their direct testimony in on the same schedule as is in the Howard cases, I would ask that we get to a spot where the testimony comes in at a time that we can have the hearings together. At least there, the commission can presumably have the ability to make a decision at the same time on these cases. And that would probably require a truncated schedule for some of the rounds of testimony, but we'd be willing to at least explore that option here to get to a spot where these dockets are complete at the same time.
Okay. And Town of Pittsfield, any comments?
I defer a bit to Pulaski on this question of timing. I agree, as we discussed in the prior pre-hearing conference, that while I think there is a way these two dockets are not entirely binary, to use that language, they are highly overlapping, and I don't think that they're both approvable absent some significant conditions. So I am hesitant. I think if we can reach a schedule that works with the hearing being held together, as Attorney Callisto suggested, I think it would be better for the commission. I think it could be challenging to proceed with these two dockets, one before the other as far as a final decision goes, because it's going to put the commission potentially in a challenging position to determine what conditions are necessary.
Mm-hmm. Okay. And commission staff.
Your Honor, just to kind of build a little bit off of what Attorney Callisto proposed, a suggestion maybe to throw out to the parties is, I understand Pulaski's concerns, and there are some outstanding data request items, as mentioned, that need responses, but I think the vast majority of those, if not all of those, are environmental related issues. And I'm not sure if that is something that is kind of the biggest point of contention between the various parties. So I'm wondering if maybe there would be some room for the parties to perhaps stipulate that some of that evidence might come in later, given that I think the potential for disagreement or, rounds of testimony back and forth on those issues is less, that maybe that gives Pulaski a little bit of flexibility as far as being able to get that information in prior to the hearing, but not by that earlier deadline.
Okay. Yeah, I'm reviewing it's the ChemNA 1 data request. There's an incompleteness letter follow-up. That's a response. But I think it's just ChemNA 1 is the pending data request that is at issue in terms of this conversation. Is my understanding correct?
Yes, I believe so.
Your Honor.
Okay, so yeah, well, it does, so those issues do appear to focus on environmental questions. You know, and I guess to the extent parties can speak to that, if they believe that that topic is one of controversy between the parties, or is this something that we could accept in terms of if the applicant needs to supplement the record in terms of its testimony on the environmental issues, we might have an availability to do that in exactly that supplemental direct. But to the extent it's going to modify or change the playing field for the parties in terms of their contested issues, I guess my assumption is that it won't do that. If that's not correct, what do parties think about that?
Your Honor, Eric Callisto for Howard. The only issue I could see, and I just don't know it until we see the response from Pulaski, is whether or not that environmental information is relevant to sort of, I'll characterize it as the alternatives analysis, right? If there's alternatives that have less of an environmental impact, that information would be relevant. As long as we have a chance to respond to that in a round of testimony after we see it, a reasonable couple of days or a week or so, then I think we'll be okay.
Okay. Any idea, Attorney Cahill, when you were expecting the response to the Chem1 data request?
I mean, they're due, 2 weeks from service, so that's going to be the 22nd. So our goal, of course, will be to get them in at that point.
Mm-hmm.
But they came in yesterday afternoon, and I haven't had a chance to talk with the consultant yet to get a sense of whether that's feasible or if we'd have to ask for additional time.
Okay. Well, I think there is an opportunity to ask for additional time if necessary actually, I can't speak, well, I mean, I guess I would have to decide that on staff's request as well. But usually I don't get involved with responses to data requests. I'm trying to see where that. So they did put a deadline in there. I don't see that here.
I think typically, Your Honor, it's in the first or second paragraph.
Oh yeah, 2 weeks within the date. Okay, yeah. So I think you'd probably need to work that out. Let's have you work that out with staff. Let's just our typical 2-week deadline. So, but I believe we could accommodate if the applicant needs to submit testimony because of this response. Now, presumably you'll be working on that in tandem with the response and the testimony. If you need additional time, we could schedule around a supplemental direct. And then hopefully they could at least catch up to the rebuttal round in order to be able to respond to that. That would be the opportunity for interveners and staff to be responding to that supplemental direct, unless we want to create another response deadline in between May 22nd and May 21st. If it's a small amount of testimony, I'm open to that too. But that's just saying if you really need to enter a new presentation of testimony in response to these data requests. Otherwise, it becomes part of the data request response package. I would expect some of this staff to offer into the record. It may be part of the environmental assessment as well. We go into formulating the environmental assessment. So in that sense, it becomes part of the record. But if to the extent that parties need to respond to it, I think we'll at least have the rebuttal round to do that if it doesn't come in on direct. So I'm not, I guess, in terms of the specific responses to the data requests, I'm not too concerned that we would be able to integrate that into the existing proposed schedule. So let me be clear, either having it come in on direct, the existing direct of April 23rd, having it come in as a supplemental direct, and then having a response to that supplement either be an additional date or have it just be subsumed into the rebuttal testimony. So that's not too concerning. I guess I'm not sure exactly how big the practical alternatives analysis gets. I don't recall seeing one of those, to be honest with you, seeing one of those before, but it looks like it's specific to the avoidance of wetland impacts. So I don't anticipate the village to be proposing a different project, in total to get to that analysis. Would expect them to be looking at rerouting things. Does that sound reasonable, or am I missing the point with the practical alternatives analysis?
I think Your Honor generally describes what the practical alternatives analysis is for wetlands.
Okay, for the wetlands themselves. Okay, yeah.
Mm-hmm.
So again, I don't know if that would most likely not going to impact the contested issues in the case, but I think we would have time in the schedule to address that if we needed to. I guess the bigger concern may be the lack of the financial consultant and the lack of an identifying one at this point. And in terms of so the project does have a cost estimate currently, and someone did create that estimate. That person's not going to be available for the hearing. Is my understanding correct?
That's potentially the concern, yes. And may not be able to testify in the proceeding due to a potential conflict, which we're working to understand and trying to get a final answer on.
Okay. Okay, well, I think if it's simply trying to accommodate one person's schedule, I think with all the moving parts here at this point, I'm gonna keep the dates as they are, and then we'll need to deal with that in the future. I guess there may be other ways to accommodate a single witness's schedule, or if you can find an alternate to stand in the shoes of the person who created the financial analysis during the hearing, we could probably accommodate that. So just in terms of certainty and for planning purposes, I think we do want to set a date today. And I think we'll be able to, work around any extenuating circumstances. If we need to create some alternative plan for one witness, that's certainly, we can be flexible to do that if we need to. So any other matters we need to talk about in regard to the schedule? Okay, so I know we did mention, I don't think I reflected it in the notice pre-hearing conference, but we did change the discovery interval for discovery response. I think it was for the rebuttal time frame, and I think we should just coordinate that. And I'm sorry, I'm talking about in the Village of Howard dockets, we made that change to the facilitating matters. I think we should coordinate that as well with the Pulaski docket. So if my memory serves me correct, it's failing at the moment. I think we did shorten that time frame. So
Your Honor, it was to 3 days from 7
I see that.
for a discovery response after the rebuttal deadline.
Okay, yes. So that makes sense to keep that the same in this docket. So let's do that here. And anything else?
So, Your Honor, if our financial witness and her firm is unable to testify, and we have to retain a different financial expert witness, how much flexibility do you see in the schedule, and is there a date by which that needs to be in?
Yeah, there won't be a lot of flexibility. I mean, it's just if someone is going to stand in the shoes of the person's already presented the testimony in order to verify it and answer questions on cross. I mean, if you can find an alternative person, then we don't need to change the schedule, hopefully. If you need to use this existing person, then, I mean, we could take this person the next day.
No, the issue is that she may not be able to submit testimony because of a conflict, not a date conflict, but an ethical conflict.
Oh, okay. I see. So they produced the analysis, but can't produce the testimony.
That is the question. We're waiting on an answer from their shop's ethics guru.
Okay. So, so in terms of the original analysis, would that have to be redone?
That is the concern, or else
Okay.
a new consultant retained who would need to verify it and do the analysis and confirm it.
Okay, well, I guess work is fast, but the date we'll set the date as it is, as we've proposed. And, I mean, I'm sure if it's a matter of engaging an alternate expert to have them verify this testimony, I mean, there's time. You have through July.
Your Honor, I guess if the concern, which I certainly appreciate from Pulaski, is that initial April 23rd date, I certainly understand that if the goal would be to submit direct testimony and they may not have an expert to be providing that testimony. I think the suggestion we talked about earlier was potentially setting a different schedule where the hearing dates would line up, but perhaps there'd be more time at the front end for Pulaski's, in this docket for the initial rounds of testimony to come in. Is that an option? I know it would get complicated to have interspersed submittals potentially, but I certainly understand the concern from Pulaski's end on not knowing whether they have an expert witness currently available.
Mm-hmm. Mm-hmm. Yeah, well, I think we'll just deal with that on supplemental direct as well. We can do that too, as long as well as the environmental issue. So if you shoot for the April 23rd deadline, if you need to file a supplemental direct on the financial issue as well, then we can come up with whether we need a separate response to that direct, or if it could be done in the rebuttal round.
I wonder if it makes sense to parties if in the Pulaski docket, Pulaski Commission Staff Direct goes in May 22nd, response rebuttal is the 21st, and so rebuttal is the 28th. I don't know if folks think we need the 4 rounds necessarily.
That's fine with the town of Pittsfield.
Yeah, I don't want to be the one who's slowing this down, but I can't agree to not having the SIR rebuttal round. If there's a way to,
I'm just saying,
Squeeze that in.
I think the proposal was just going to be applicant direct May 22nd, all party rebuttal June 21st, all party SIR rebuttal June 28th, rather than the 2 rounds of direct.
Right,
Yeah,
but that's still,
exactly.
that still eliminates a round of testimony for my side.
Yeah, what's on the table is really if you need a supplemental direct, we'll work out the filing of supplemental direct. And if either the response to that would be instead of the parties generally opposed and commission staff direct, the response to that supplemental direct will either be a special rebuttal for the supplemental direct or just be in rebuttal. And I think what we have to look at is the timing of that. So for example, if supplemental direct's filed on May 1st, supplemental direct by the applicant May 1st, then the rebuttal to that, or the rebuttal to that could be in between May 22nd and May 21st. Sort of the initial answer from parties and who oppose and staff could be in between the second direct and rebuttal. So everyone gets a chance to respond to everything at the same time. Or we can just leave it for June 21st, would be parties generally opposed and commission staff's first opportunity to respond to the supplemental direct. So that just might make most sense right there, but I think we want to just leave that open. So if you need supplemental direct, it could come in on a request that's stipulated in terms of how parties want to respond to that. And they can decide to either try to set a date that's interspersed into the existing schedule or agree to make the rebuttal date the response to that supplemental direct.
Your Honor, that was going to be my suggestion as well. It seems like if Pulaski can submit most of the direct by the April deadline, if we're only talking about potentially, one or two witnesses or the environmental issues or whatever, that could come in through supplemental direct. And if it's only a witness or two, there might even be time then that the responsive parties would be able to work that into the then existing deadlines for the subsequent rounds of testimony. Or if additional time is needed, then the parties could ask for an interim deadline for responding to the supplemental direct.
Correct. If we have to just take testimony on the stand, we don't get to the rounds we need to get to, we'll just do it on the stand. But I guess this all sort of assumes that the financial analysis won't change significantly from what's in the application as to what's going to be produced potentially by a different person. So, my assumption is we're going to see the same financial parameters in this that will match the application. So that may that may complicate your job a little bit more, Attorney Cahill. But yeah, I don't know if we can, if we're going to present a financial analysis that pulls the rug out of the application and it's happening later in the process, certainly then, much later than the application has been put in. And I don't know how staff's going to feel about that. I don't know how the other parties may react, but so we're kind of hoping we're operating under the assumption that the financial conclusions of the applicant are going to be the same, although they may be presented by a different expert. So that being said, any questions?
So perhaps rather than continue to speculate about what will happen, hopefully we'll hear from our consultant soon. Based on that, I will reach out to opposing counsel and talk about how to proceed with supplemental or a schedule that will make sense depending on what we learn. And then if we need to, we can notify the commission and go from there.
Right. I think it seems like we have agreement that we're going to shoot for the July 9th hearing date for all three dockets. So I can backpedal slightly saying, I'm going to issue the the schedule as it is, but if parties do come up with an alternative, they can also always request that we change the schedule. But I think in terms of our expectations going forward, it's going to be the current proposal. Okay. All right. Anything else? All right. Well, thanks everybody. Take care, and we're adjourned.
Have a good afternoon, everyone.